welcome to this webinar on impact of business, corporate law, employability, and lockdown compliance. This is a series of webinars from FICCI in cooperation with Cyril, Amarchand, Mangaldas. Here. We have pleasure to welcome Cyril, Shroff, Bharat, Vasani, and Rashmi, Pradeep, who will be the experts on this panel, and will take you through a detailed presentation, and this would be followed by question and answer. Team of Abba Seth and Jyoti and team have really worked along with Cyril and his team to enable this. Thank you all for joining. Good morning, and with this brief introductory remarks, may I hand over to Cyril. Cyril, over to you.
Thank you, Dilip, and thank you, FICCI, for partnering with us on this interesting webinar. There is already a lot of information and conversation about the entire kind of Corona and COVID crisis, but every day there is something new that is happening. And part of what we wanted to do through this initiative was to partner with FICCI to keep the corporate constituency updated on latest developments, give them insights, and also be available effectively as a helpline to help them deal with the day-to-day questions that arise. There is a change that is made almost on a daily basis, sometimes multiple times during the day, and it's not an easy task to keep on top of these issues. But nonetheless, we have done our best to put together this presentation, which is updated as of yesterday. As Dilip mentioned, this is a series of talks. Today is the first one. We have another one coming up this Friday on force majeure and material adverse change clauses. That is that webinar. The second webinar is only on that subject, and we have invited Dr. Abhishek Singhvi, who is a leading senior advocate, to join us on that conversation. So whilst we will be touching force majeure very lightly today, the main conversation about that will be happening on this Friday. And for those in the audience who are interested in that subject, in fact, everybody is, should definitely make it a point to register for that one. Before we start the formal presentation, I just want to make a few initial points. First, in terms of India's position on the medical response, the fact that the Indian government has acted quickly and went into a lockdown mode and has enforced social distancing has been extremely effective in controlling the rapid spread of the disease. In fact, our total case count for India is about the same as the death count in the United Kingdom. So that should give you an idea of the fact that it has been successful. Obviously, we have not tested as extensively, and once a lockdown is lifted, some of these numbers will spike. And I'll come to some of the thoughts about that separately. On the economic side, the GDP forecasts have been drastically revised. Almost every expert institution that had predicted and forecast the growth on a pre-COVID basis have largely revised their predictions and brought them down. Some have even put us in the negative category, but safe to say that it is likely to be in the between 0 to 1%, which is for the first time since independence that we would be having such a low growth rate. And the challenge has been that we are facing a shock not only on the demand side but also the supply side and also the market. So all these three shocks happening at the same time is bound to have such a severe repercussion. And we're still at the early stages. The coming weeks and months will unfold what really lies ahead. I'm sure the government is thinking of some form of stimulus, and in due course will come out with it. So what's on the mind of corporate India today? Multiple things, but if I could list in my perception are the top 3 or 4 issues. First and foremost, I think they're worried about the health and safety of their organization and their teams and their people. This is the number one priority for most of the boards, which goes down not only to the technical legal compliance of the restrictions, but also to make sure that there are no cases, because even one case in a factory would elicit a government response of shutting down the whole factory. So keeping health and safety as a number one priority is clearly the thought process for most managements and boards. The second, and this is what I think people are feeling currently, is what the post lockdown scenario is likely to look like? What is the post work from home scenario? How will we exit the lockdown, and what happens thereafter? So how is social distancing going to be enforced in office spaces? How is social distancing going to be enforced in factories? How should it actually work out in terms of in practical terms, and how is the hygiene going to be maintained? Therefore, and it's quite obvious that at least a partial workforce from home is looking like a reality for a long, long time. After the lockdown is lifted, there could be a second wave and a second round of lockdown. So all that is being factored in as well. Again, on the business sides, what are corporates thinking of? I think they're coming to terms of the shock of the income levels having drastically fallen. There are many businesses which run on very thin margins, and a couple of months of no income clear puts them in the red category immediately. Those with highly leveraged balance sheets are thinking about how they're going to repay their loans or restructure their balance sheet because there is not enough clarity in terms of how these issues will be dealt with. Yes, there are temporary moratoriums and deferments, but there has been no deep restructuring proposed as yet. So these are some of the thoughts that are on the minds of most corporates. On a more long-term basis, corporate India is thinking about new business models itself. There are some entrepreneurs who are thinking about and asking themselves existential questions about whether the business has a future at all and whether they should be reinventing themselves or getting into new businesses. So the business model is up for discussion as well. So survival in a post-COVID world is definitely a new skill and a new dynamic that is going to be quite different from the past. The future of work and the future of travel is completely up for grabs. I think, as all of you know, some industries such as the travel industry, airlines, hotels, hospitality, restaurants have been challenged even more, and those will have to sort of be dealt with on a special basis. We see an impact on deal making as well. We do a lot of corporate M&A and investment work, and we've seen, whilst the firm has been busy in the month of March and April, but I believe that a lot of it is because of the momentum of pre-COVID transactions, which are coming to a close. Going forward in a few weeks or months from now, I think we will see that there'll be a significant demand contraction in terms of deal activity. That being said, there is likely to be interesting deal activity on the other side of COVID when there is some sort of normality and a new normal emerges. Private equity will be back for a lot of repriced transactions. Consolidation M&A will occur. There will be many assets which will be up for sale or restructuring. So I think deal activity will go through a fall in the short run, 3 to 6 months, and should come out on the other side of it with more robustness, but at a different price. Now, what are we going to discuss today? As I said, this is first of the series of webinars. We are going to talk about the implications on lockdown compliance, employment law, and corporate law compliance, and a little bit of some of the restructuring stuff. We will talk in a very fleeting way on force majeure, though, as I said, we will discuss it in more detail on the Friday webinar. So just to share with you on how we are dealing with this work, and if you might want to keep that in mind, is we have created a special COVID-19 advisory team, which is a multidisciplinary team which draws upon different disciplines on employment, compliance, corporate law, corporate governance, healthcare, dispute resolution, insolvency, data privacy, and things like that. So this is we kind of combining the different specialities of the firm and I put them together in this format. Please take a note of the email ID in case you have any follow-up questions from today's event. Please feel free to write to us. So with that, let me now introduce my co-panelists. The speakers, other than myself, are Bharat, Vasani, and Rashmi. Bharat Vasani is a very senior practitioner. He has been with the firm for a few years, and before that, he was a group general counsel of the Tata Group for 17 years. He is a key member of our COVID COVID Advisory Group, and his specialization includes company law and corporate law. Rashmi Pradeep is the head of our employment practice based in Bangalore, been with the firm for over 17 years, and is an expert on all the employment and compliance parts of this situation. So these are the key areas for consideration. Now let me hand it over to Rashmi.
Good morning, everyone, and welcome to the session. Today, we've got a presentation for you divided broadly into 5 parts, and I'm going to cover COVID regulations and labor and employment, and Mr. Vasani will cover corporate governance, regulatory relaxations, and contractual considerations. So I'm going to dive straight in because we have a lot to cover. So it's important, I think, for all of us to understand the regulatory framework that we are operating under today, and the 2 main legislations that have been brought into play by the state and the central government are the Epidemic Diseases Act and the Disaster Management Act. These are the 2 main legislations. Separately, you have the Essential Commodities Act, the ESMA legislations at the state level, and the CRPC, which are enabling legislations which allow some of the orders and the notifications coming out of the Disaster Management Act and the Epidemic Diseases Act to be properly implemented. So I'm just going to directly go into the state legislation. So currently our states have all invoked their powers under a legislation that was passed in 1897, being the Epidemic Diseases Act. This legislation was actually put in place to deal with the bubonic plague in Bombay in 1897. It's a pre-Independence Day English British era legislation which has been brought into play. It's not been used for over 120 years. It's one of the shortest legislations in our law books today, with just about 4 sections. And the main intent of this legislation is to prevent the spread of dangerous epidemic diseases, which COVID-19 has been declared as. There's very limited power to the central government under this legislation. However, the state governments have been given extensive powers, essentially to formulate any regulation that is necessary to contain the spread or the outbreak of a dangerous epidemic disease. If there's any violation of any orders passed under the Epidemic Diseases Act, the penalty is for contravention of Section 188 of the IPC, which is basically the crime of not following the directions of a public servant. It is under this Epidemic Diseases Act that you saw from March 12th to March 14th, all of the states enacting what is called the state COVID regulations. These regulations, the first state to do this was the state of Karnataka, followed closely by Maharashtra. The state COVID regulations have been put in place for a temporary period of 1 year. And while they provide for many things, including how health services and hospitals, etc., would deal with a case of COVID-19, I think what's important for us to note on the state COVID regulations is that it basically empowers, each of the states have empowered the district administration to implement any kind of containment measure to ensure that the spread of COVID-19 is contained. Specifically, these powers include the ability of the district management to seal geographical areas, close public spaces, and if there's any violation of these COVID regulations, then there's criminal penalty, like I mentioned, under Section 188. Thereafter, after the state COVID regulations were put in place, you saw in the time period of March 22nd to 24th, the state lockdown notifications that began being issued by various states. The state lockdown notifications essentially provided for sealing of the state borders, restriction of movement of people and transport, closure of shops and commercial establishments and factories, except for essential goods and services. Some factories that could not suddenly close down and required to operate continuously. For example, if you had large boilers or large machinery that could not be turned off overnight, they were allowed to continue to operate so long as you took necessary permissions. And of course, in those areas, if you had to operate in certain states or in certain cities, you were required to get passes or certificates. Now, the state lockdown orders, as you're aware, while we saw them between 22nd and 24th, we saw them being reissued in the March 31st timeframe to ensure that it coincided with the national lockdown until April 14th. And now you've seen state governments again issue revised lockdown notifications to ensure that the lockdown period now extends up to May 3rd. We have seen a couple of states, and I'll go into some detail, extending that beyond May 3rd as well. So this is the framework under which the states are operating. If moving to the empowering legislation at the central level, The center is operating under the Disaster Management Act, and COVID-19 has been declared as a disaster under this legislation. It allows the central government to direct states to take actions to contain the disaster or to manage the disaster. And it's pursuant to this power that we've seen the MHA issue orders, the lockdown orders. So the first lockdown orders started coming out from March 22nd. It was a phased lockdown that began. But on March 24th, we had the national lockdown that was imposed for a 21-day period until April 14th. There were specific containment guidelines and measures that had to be followed by states and union territories. State governments were required to strictly implement the MHA orders and not to allow for exceptions or deviate away from the MHA order. Subsequently, we saw a lot of addendums coming in to elaborate on the list of essential goods and services. The general principle being that as long as you were involved in the supply chain of essential goods and services, you could continue to operate. In the first set of lockdown orders, there's also the order in relation to treatment of migrant workers, which is an important notification. It specifically touched on employment of workers and the requirement to pay their wages. And I will go into that in some detail when I deal with the labor and employment issues. Thereafter, on April 14th, we had the extension of the lockdown, where the lockdown was extended till May 3rd, but in two phases. Up till April 20th was a continuation of the 21-day lockdown period. And thereafter, from 20th, the states were allowed to relax certain organizations and operations and establishments to continue as long as they were not in the containment zones or in hotspots. The major relaxations dealt with industries located outside municipal limits, units located in SEZs. There was resumption of agricultural activities, and certain MSME activities were also permitted. What is to note under this revised set of, under the revised lockdown notification is that states had the right to impose stricter measures than what the MHA had brought about or had prescribed. So under the MHA notification, what is being allowed from today is RBI regulated financial markets, entities, NBFCs, ATMs, SEBI and capital market services, insurance companies, manufacturing establishments and SEZ EOUs, supply chain of essential goods, including e-commerce. E-commerce was actually permitted under commercial and private establishments, but by an exclusion notification issued yesterday, it was removed from the ambit. Industries in rural areas are allowed to continue to operate. Manufacturing units of drugs, pharmaceuticals, etc. Food processing is allowed to operate. ITES with 50% strength is allowed to operate, and construction activities in roads, buildings in rural areas, and construction projects within municipal corporations where workers are located at the site are allowed to continue to operate from the 20th. Of course, in order to be able to do this, there is a requirement that you have to follow certain processes and certain conditions, and I'll go into that in a bit. But what will remain shut, and this is important to note, that all domestic and international air travel of passengers is prohibited other than for specific reasons. All passenger movement by trains and buses, and more importantly, taxi and cab aggregators have been prohibited from operating. Inter-district and interstate movement of individuals, except for reasons which are permitted, are also prohibited. Cinema halls, malls, shopping complexes, theaters, auditorium, entertainment parks, all to remain closed, and all social, political, cultural, religious functions also prohibited. In order to be able to operate, if your organization or establishment falls within the exempted category, then there is national directives that have to be followed at a minimum. That is, if you're in a public space, you have to ensure that you're wearing a mask or a face cover. There are specific social distancing norms that have to be followed. No gathering of 5 or more persons. Strict ban on sale of liquor, gutka, or tobacco. Within the workplace, there is a requirement that you shall have temperature screening, and sanitizers shall be provided to all employees attending. Between shifts, there has to be a gap of at least 1 hour during which the entire area has to be sanitized. There has to be staggered lunch breaks. Any person above the age of 65 or someone with comorbidities or anyone with children below the age of 5 should be encouraged to work from home, and you are not required, and you're not supposed to have large meetings at the workspace. Specifically for manufacturing establishments, in addition to what I've just mentioned for workspaces, there's also a requirement to ensure intensive communication and training of good hygiene practice. Special standard operating procedures for social distancing within workplaces are also specifically prescribed. So for example, you have to ensure that all of your work areas, vehicles, machinery, etc. are properly disinfected. You have to provide transportation for workers who are coming from outside. So if you're not staying in the area of where your factory is located, then you have to arrange transport, of which only 30 to 40% capacity should be filled in the vehicle. Non-essential visitors are not permitted. There's a mandatory requirement to thermal screen and a mandatory requirement to ensure medical insurance for all workers. There should be a gap of 1 hour between shifts. And it's also important to ensure that your employees are available of nearby hospitals and clinics which treat COVID-19. So this is broadly the conditions that have to be complied with. I will just go briefly into some of the states that have put out notifications yesterday on how they will be relaxing their offices and workplaces which are permitted to operate during this period. So Karnataka has actually said that for the next 2 days, they will continue in a full lockdown mode, and only on 21st, they will determine which areas can begin working. Similarly, Delhi as well has extended the full lockdown for another additional 7 days, and they will reassess towards the end of that 7-day period. So in Delhi, it is the full lockdown. None of these exceptions are available in Delhi. Telangana has actually gone one step ahead. They have said that till May 7th, they're in full lockdown, and they will assess the situation closer to May 7th. They have also tightened some of the existing exemptions that existed. For example, all food delivery apps have been, or food delivery platforms have been banned operation in the Telangana area. You have AP, Tamil Nadu, UP, and Haryana who have more or less mirrored the MHA notification and will begin operations today, assuming that establishments are complying with the SOPs that I just mentioned. Maharashtra also has made some tweaks. For example, confectioneries, sweet shops, etc. are allowed to operate in Maharashtra and also in West Bengal. And in Kerala also some tweaks have been made to the MHA notification where food processing units, etc. are allowed to stay open. So this is broadly a quick update of what's happening at the state level. Some of these, like for example, Telangana, we're relying on press reports that are coming out of the CM's office. Last night, we haven't seen the actual official government notification coming out as yet. And this is something that we expect more clarity within today and tomorrow on how these establishments will actually get back to work. So moving into labor and employment, I think before I go into how these COVID regulations actually have, changed or affected labor relations in India today, I think it's important to give you a quick recap on existing labor laws and how these existing labor laws, which would have normally come into play on some of the decisions that a lot of employers are today contemplating, given the lockdown and the impact on their businesses because of the lockdown. So some of the questions that we are getting asked are, can we terminate our employees? Can we lay them off? Can we change their service conditions? Can we change leave policies, etc.? And for all of this, India actually has a very robust, though slightly complex labor law regime, which would deal with it and which prescribes very clear processes which ordinarily would have to be followed. So for example, if you were terminating a workman, and if you were a commercial establishment or a factory with less than 100 workmen, you would have to give 30 days notice and 15 days wages for every year of completed service if you were terminating a workman. Similarly, if you were a factory with more than 100, and some states that limit is 300 or 500, then you would have to give 90 days notice, 15 days wages, and also get government approval before terminating workmen. For non-workmen, of course, you would look at the employment agreement and company policies and follow process under that. For your layoff provisions, again, layoff is very loosely used nowadays. A lot of times when people refer to layoff, they're actually looking at termination, but layoff is a technical term under the Industrial Dispute Act. It means a situation where an employee is willing to work, but an employer is unable to give that employee work. So if your employee standing orders specifically provide for layoff situations, then in the event of a natural calamity, factories which have between 50 and 99 workmen are enabled under law to reduce pay up to 50% and retrench those workmen after 45 days because they are unable to give them work due to a natural calamity, which COVID-19 would fall within. And if you had more than 100 workmen, you could reduce the pay up to 50% for 45 days and then retrench, of course, with government permission. A layoff in every other situation would require specific consent of employees. Change in service conditions, again, the Industrial Dispute Act is very clear. It provides that if you are changing service conditions, be it wages, leave, or any kind of customary benefit that has accrued to a workman, then you would have to give them 21 days notice before you can make that effective. In any other situation for a non-workman, you would look at company policies or get consent of the employee before you make such change effective. So this is broadly a recap of existing labor laws which would normally have come into play. But what we've seen pursuant to COVID-19 is directions and coming out of various government departments, be it the Labor Department or the state departments, that factories and establishments, at least during the lockdown period, are not to terminate employment of employees / workers / contract labor. They use this terminology quite loosely, or reduce their wages. There is a positive obligation that is being cast on employers today to ensure that wages is paid in full during the lockdown period. Now, initially, these advisories came out of the Ministry of Labour and Employment around March 20th. You saw it coming out of the center, and then the same language was kind of mirrored across the board in many of the from many of the state labor departments. It was not issued under any specific legislation. It seemed more in the nature of an appeal, and it didn't provide for any kind of penalty if you violated these advisories. So initially, when we all read this, we thought it was just good to follow, but not mandatory. Thereafter, when the lockdown orders came, and especially the state lockdown orders in that period between March 22nd and 24th, we noticed that in some of the state lockdown orders, specifically Karnataka, Telangana, Tamil Nadu, and I think even Delhi had it, it specifically restricted employers from terminating employees and specifically also required them to be paid full wages. While Karnataka, Tamil Nadu, and Delhi had more recommendatory language, you had Telangana, which had language that said that you shall not terminate and you shall pay. And specifically saying that if you did not comply with them, these orders, you would be liable for prosecution under Section 188, which is anyway the penalty that would have accrued to you in the event of breaching any of the lockdown orders. Thereafter, you had the MHA order, and this is an important order. This is an order that came out on March 29th when you had the large exodus of migrant workforce across state borders. On a Sunday evening, you had the MHA issue these orders, which, while the entire notification seemed to be in relation to migrant workers, there was this one clause which directed employers, and they used the word in industry, shops, and commercial establishments to make full payment of wages to workers during the lockdown period, thereby kind of expanding the scope and not limiting only to migrant workers. It specifically also imposed personal liabilities on state authorities who did not ensure enforcement of the MHA order. Immediately after that, on March 30th, we had the Central Labour Commissioner issue directions to all of the regional heads, informing them, and again taking cue from the Central MHA order, that if any distress calls were received from employees and workers, and they used both words, regarding any hardship in relation to their wages or employment, the state authorities were to rigorously take up actions with the principal employers / contractors and against public and private enterprise, and to provide feedback on this. So automatically, you saw the CLC issuing orders pursuant to the MHA order and kind of directing all state authorities to take rigorous action against employees who violated the order. Thereafter, on March 31st, you had the Supreme Court in its order in relation to migrant workers, specifically observing that non-compliance with any advisory, and now we go back to the first set of advisories that we spoke about, which is issued in the nature of an order made by a public authority, would attract penal provisions if you did not follow it, and that all state governments, public authorities, and citizens of India are required to comply with these directives and advisories issued by the Union of India, thereby lending another level of formality and mandatory nature to some of the advisories and directives coming out of the center. You also had the Home Secretary immediately after that quoting the Supreme Court and again instructing all states to ensure that all advisories were being followed. So this is the broad framework of what we've seen. Now, non-compliance with all of these advisories today exposes you as an employer to possible prosecution under Section 188. It's a cognizable offense, but it is also a bailable offense. Cognizable meaning that a police can arrest without warrant, but it is bailable, which means that they have to grant bail immediately. And then you also have Section 51 of the DMA. Under Section 188, imprisonment up to 6 months or a fine of up to ₹1,000. So the current position where we are today is this, that strictly speaking, the Epidemic Diseases Act and the Disaster Management Act really grants power to the center and the state to prevent the spread of a disease and a disaster. And the big question here, I think that we have to ask is whether it grants powers to the state and the center to interfere with what is otherwise standalone labor laws and restrict employers to terminate employment or reduce wages. And an argument may be made that, you know, some of these orders coming out of the state and the center are ultra vires, the parent legislation under which they're issuing this. To this extent, there has been a writ petition filed in the Supreme Court in Nagrika Exports. This was filed on April 14th, raising some of these very questions. And it will be interesting to see how, how the Supreme Court interprets some of these orders that have come out of the state and center. But while that is being decided, I think what's important for us to note today is that today, if you take action against your employees, there is a very real risk of regulatory action, which means that the authorities at the state level could come after you. And we've seen some of that happen. In fact, this morning, we've seen that in Pune, one of the large IT companies, they have received a notice from the labor authorities on rolling back a decision that they made on putting employees on unpaid leave. So this is a space to be watched out for, and this is a real risk that you could be facing. You have the automatic reputational risk of social media and negative press coverage that would flow both from the reduction decision itself of whether workforce or salaries, and if any regulatory action is taken, then the outcome of that as well. And you also have the risk of a sympathetic court. So today, if you are to challenge one of these orders, or if you are brought before the court by a disgruntled employee or prosecution by the state, the chances are that the courts in equity will find in favor of the employees and the state. We are in an unprecedented situation right now. Very hard to rely on any past precedents to see how the courts would react. There have also been numerous government initiatives, and we're expecting some more as well. Very broadly, these government initiatives fall in a few schemes. One is under the Provident Fund Act. The Ministry of Finance announced, and there has been a EPF scheme amendment to this effect as well, that for the next 3 months, all establishments having less than 100 employees and of whom 90% earn less than rupees 15,000 per month, contribution of both employer and employee will be made by the government. There's also, from an employee perspective, employees are allowed to withdraw up to 3 months of basic and DA, or 75%, whichever is lesser, standing to the credit of a member. During the lockdown period, apprentices are to be paid their stipends, and there can be a reimbursement claimed by the employer from the government. In relation to building and construction workers, the cess that has accumulated over the past years are being transferred electronically into construction workers' accounts. And on state government initiatives, a couple of states, Karnataka and Telangana, have specifically issued orders under their Holidays Act. So example, Karnataka, under the Shops and Establishments Act, have specifically declared an additional leave of 28 days for anyone who has tested positive for COVID-19. And Telangana has actually declared a paid holiday for those during lockdown who are unable to come to work. So these are some of the government initiatives. There's also been, a lengthening of filing times under various legislations, and including payments under the EPF and ESIC Act. The contributions can be paid a month later. Now, some of the FAQs and questions that we have been getting over the past month or so, and we've kind of bucketed into two specific boxes. One is on current questions, and on the left side, all of the questions that we're getting really relate to cash flow issues and cost-cutting measures that employers are having to put in place because of the fact that, operations have been put at a standstill. These include deferment of payouts. So, for example, in the March-April timeframe, I think everyone is due to pay out bonuses. So whether some of these bonuses can be actually deferred to a later period, reduction in salaries, the possibility of putting people on furlough, which is leave without pay, reduced work hours and reduced pay, reduction in workforce and retrenchment, reduction from paid leave balances, and mutual severance agreements. So generally, the principle here right now is, given the advisories and given the risk of regulatory action, the point that we have been making is, so long as you can do all of this with the consent of the employees, then you should definitely be in an okay place and not, exposed to the risk of regulatory action. So all of this, and we've seen companies do this quite effectively and efficiently, where they have managed to get consent of employees for reduction in salaries, for going on leave without pay, or even terminating employees where they've, kind of done a resignation route, where employees are willing to resign with a payout of some additional amount than what they have under the contract or under law. And this is something that has been effectively done by a lot of employers. And I think the trick here is to ensure that you're being very transparent, that you are, ensuring through very effective communication that you have the buy-in of the employees. And we've seen that this has been happening across the board. Most employers have been quite successful. What are the questions that we are expecting and which are around the corner? I think these are the kind of questions that we've already seen come in. One is abandonment of essential services rules. A lot of our clients and companies have kind of reached out to us saying, we are in an essential service, we are required to operate during the lockdown, but our employees are not turning up for work. So this is an important thing, because some of the state governments, for example, the Goa state government, the Labour Department has clarified this position. They've actually issued a notification saying that employees who are mandated and required to come to work, who do not come to work, can be terminated, or action can be taken against them by management. If the ESMA, that is the Essential Services Management Act, is actually notified or brought into play by any of the state governments, then this is something that will also help in ensuring that employees come to work in essential services roles. We've been getting questions on director liability, and Mr. Vasani will go into that in some detail on the corporate governance part. Extent of liability for non-compliance of contractors. So even if I pay my contractor and my contractor doesn't pass on the salaries or the amounts to their contract labor, then is there liability for me? That's another question that we're getting a lot of, and the answer to that is, irrespective of whether the COVID regulations existed or not, under the CLRA, you were to, as a principal employer, liable if a contractor did not pay salaries to the contract laborers. I think you will see, as the lockdown period continues, that a lot more employers are going to be forced to take hard decisions. I think a lot of companies could manage for a 21-day period, but as this lockdown continues, I think some hard decisions will have to be taken, and how those decisions are to be documented, etc., is something that we expect a lot of questions on. We also expect a lot of questions on claims that employees can make who get COVID-19 at the workplace, and I think you'll see this, whether it is your essential services delivery person, or people at or your health and safety staff at hospitals. What are you going to do if claims come from employees because they're exposed to COVID-19 at the workplace? You have your Employee Compensation Act, of course, that will kick in, but you should also look at other liabilities that may accrue. It's important here to ensure that you're strictly complying with the SOPs that the government has specifically prescribed, to ensure that you are not in breach of those, because that will expose you to additional liability. Work from home has also given rise to a whole lot of new issues, and a lot of companies are looking at revising their policies, because with work from home, there are new set of issues, things like how do I track overtime, how do I track IT issues which arise and thereafter result in overtime. So a lot of things that companies are having to rethink. The concept of workplace itself, because suddenly you have expanded your workplace to your home. What does that mean under separate legislation? So that's another analysis that will have to be done, and I think we expect a lot of questions in this area as well. So this is broadly the employment law framework and what we're dealing with today. I'm going to now hand over to Mr. Vasani on the next part of this presentation, which is corporate governance.
Very good morning to all of you. We are currently in an extraordinary situation for the corporate boards. The situation is arisen out of this pandemic, which most boards were not prepared for. In fact, point out one board today which said that I had a playbook ready, that if a pandemic happens and my revenue turns zero, how would I operate? How would I manage my cash flow? If any board is there in the world who has a complete playbook ready, I think all the board members should get Bharat Ratnas for that. I don't think there is any board in India or US or UK or any other country has claimed that they had a playbook ready to deal with the situation. No risk management committee had envisaged this risk, that there could be a complete shutdown of all the economic activities for such a prolonged period and a very significant contraction in demand. So what has happened now, that the boards, how should a well-functioning board behave in a current situation? I'm not going to deal with the legalistic description of duties of directors under 166 or LODR, that's theoretical. I would deal with the practical part of how the board should react in a situation on a day-to-day basis on a practical terms. Now, first major issue which most boards are confronted with is, see, in Indian boards, typically there's a system that the annual operating plan for 2021 would have got approved in a board meeting held in February. Now, that time the COVID-19 was on a horizon in China and other countries, but not so kind of with a profound impact. It came like a tsunami, nobody was prepared, and with a matter of week or two, everything was shut. So I think that is the first thing board will have to do, is that the annual operating plan, which was approved by the board in February, is no longer valid, and they'll have to work out on a contingency plan for 2021. Now, one of the issues which boards are facing today, that what should be the degree of their involvement, and I'm telling you that the approach which boards should be taking, and international consultants have been recommending, that the board undoubtedly in this situation needs to adopt a more hands-on approach, unlike just coming to attend a board meeting once in a quarter. But there are two situations we are seeing, and I've been speaking to several board members, chairmen of the board, chairmen of the audit committees, NRCs. What I find is that some boards have become ultra hyperactive, too much worried, and almost demanding a weekly meeting from the management, board weekly update and almost fortnightly board meetings. Now, one important advice which I would like to give is that this is a situation where the management team is already overstretched. They are handling with unprecedented crisis, which none of the management team member was ever prepared for. No CEO was prepared for. So allow them to function. The role of a board in such a situation should be that it should not become a burden on already burdened management team. It should rather augment the capacity of the management team. What I mean is that, yes, you have every right to be kept informed. You have a duty to be kept informed, but you do not create a situation where management teams most of the time goes on managing its board members rather than managing the situation on hand. Now, some of the practical tips which I would give for the board members in India is that ideally a good functioning board should empower the management in this way, that number one, the boards are better at handling the external and internal stakeholders in certain situations. Let the management team focus on crisis. The first thing the board should do is to empower the management team. That if there are urgent decisions required, don't wait for board approval, we'll ratify your action. Take immediate action. So if that comfort is there from the chairman of the board to the CEO that I will back you up, just take right action immediately. Don't wait for calling a board meeting or passing a circular resolution. The next major thing is, depending on the expertise. Now, I think if you are addressing to the internal employees and giving them a comfort, it would be very good if the chairman of the board sits with the CEO when addressing the employees. Second very important thing which can be done in a situation, most of the Indian corporates are very heavily leveraged. And because of which they are facing an extreme liquidity situation. So what should an audit committee chairman do is that he should work with the CFO and the finance team to work out the strategic cash flow planning, that undoubtedly there's a liquidity crunch. So he should accompany the CFO to deal with some of the strategic lenders, key lenders of the company, where there are debt covenants which you are breaching because you don't have the income and you have an obligation to pay interest and other things. And of course, I'll deal with the RBI relaxations a little later. But this is the area where audit committee chairman can do two things. So I am basically going to say that the chairman of the audit committee should help the CFO in dealing with the finalization of accounts for 31st March 2020, where there are serious issues have come up, and I will deal with those issues. Second thing is should help the CFO in cash flow planning. See, this is the time where management team needs a very wise and sagacious advice from the board members. They are doing firefighting on the job on a daily basis. So if there is a senior audit committee chairman who can sit with the CFO and kind of help the CFO in help advising them on taking the right sections on some of this front, it would be very good. The second is that the chairman of the NRC nomination and remuneration committee should sit with the HR head and the CEO and work out a plan on how do we meet the salary wage bill for the next couple of months. Is there a need for right sizing the organization after the local lockdown order is lifted? And of course, subject to all these restrictions which Rashmi pointed out. And what should be the kind of the new pay structure? Already some of the CEOs like Mr. Uday Kotak has announced that he's going to take only ₹1 salary for the entire next year. So what should be the curtailment of top management's compensation? So if all these things are properly done, the NRC chairman can help the HR head and the CEO in planning those kinds of stuff which are very critically required. Then other thing which you can do is, the board member which is every board is generally a member who has a legal background. I think the board member with a legal background can sit with the general counsel and the company secretary to see which are the contracts where we may be breaching the covenants, which are the contracts whether we should invoke the force majeure clause for a material adverse change clause if there's an M&A transaction going. And for that, do we need any external advice? This one should not become trigger happy when we deal with this issue of force majeure and MAC more in detail on the session on 24th. You will realize that these are not very easy options and the burdens are very strict. So I think the board member with a legal background can help the general counsel and the company secretary to look at some of those contracts where the leases are there, whether we can request the landlord to defer the lease payments for a few months. Particularly, this would be relevant to companies which are operating in sectors like front-end retailing, theaters, malls, restaurants, that whether you can request the landlord to kind of defer the rent. So this is one area where the board can help. Then every board in India generally is a very senior retired bureaucrat or a government servant who joins the board post-retirement. Then these are the right people with whom I think the CEO can accompany to meet the regulators. If you are an insurance company, IRDA, if you are a telecom company, TRAI, keep the regulators on your side that this is what is happening. This is the way we are trying to deal with the situation and how we are going to handle this situation. Then these are the very, very, some of the very operational help can be made, but board also is required to take certain strategic decisions in this hour of crisis. What is the strategic decision? What is the liquidity situation of the company? And what is the debt burden of the company? And what is required to be done? Because there are some very hard decisions which some of the boards will have to take in a very short time. Most of the Indian corporates, I am sorry to say, are over leveraged. And they realize with a lot of grief that this kind of crisis, a lot of them have foreign currency borrowings of very high amount, and because of the dipping of Indian rupees vis-a-vis US dollars, the liability in foreign exchange has become very, very high. Now, as a result, there are certain critical decisions to be taken with regard to dividend payouts. We are already in the AGM season. The board meeting, the government did not extend the financial year. So everybody is having the board meetings now. They're closing the accounts, working from homes. Big challenge. And I'm going to deal with some of the accounting issues shortly, but I want to deal with these issues first. So the first decision is, should we reduce the dividend payout? Let me tell you, there are companies listed companies which had declared interim dividend in February have decided to call off their dividend subject to SEBI approval. Then the CapEx plan. Normally in February, the boards would have approved the capital expenditure plan for 2021. Now, what is this CapEx plan? One needs to very seriously hard look at what are the expenditure which can be deferred, because in this kind of crisis, cash is king. The more liquid you have better ability to deal with the situation. So look at the CapEx plan, eliminate all completely avoidable item of capital expenditure which can wait till next year. I talked about CEO compensation and top management team compensation. Then the board also needs to be very careful in cash flow planning, that there are no pressures which are there on management team to make any preferential payment to any particular line of creditors, because what happens if the company goes into bankruptcy. Section 43 of IBC will kick in for preferential payment. Then other decision which many boards are today taking, that should be immediately before the economy worsens further in going forward in August, September, October, should we be immediately do some QIP issue or a private placement or a rights issue or bring in a private equity player in the company. So these are very important decisions where, unfortunately the stock market is crashed. So there are some opportunistic thing which is available now in terms of should the promoters do buyback to reduce the because the buyback can be done at a very attractive prices just now. Now, all these issues of capital raising would require a lot of host of considerations. Now let me turn to the account first. Before this slide, I would like to deal with some of the accounting issues which have come up. And I think many of the boards are completely unprepared to deal with. Broadly, there are 10 to 11 very serious issues which have come up for the company under the current accounting standard, both those who are following Ind AS as well as those who are following the Indian accounting standards. The first major issue which has come up is the impairment of assets. It's a very long discussion, but I tell you, impairment of assets has become very contentious issue between the company management and the auditors. And this is taking away a lot of time of the finance team on how to convince the auditors about the impairment of the assets under the current accounting standards. The second major issue which has come up for a lot of retail companies which have a lot of, the valuation and profitability of retail company depends on inventory. And many inventories are just lying stuck in a large stores and godowns. They have not been able to access for more than 45 days because state lockdown started much earlier. So what do we do? Should there be a revaluation of inventory and should there be a write-downs, because there could be some perishable items which would have completely lost the value. The third major issue I'm told is facing most of the accounting team and the CFO is the revenue recognition. In this case, everybody had planned and done sensitivity analysis that my revenue may drop by 20%. What would be the profitability like if my revenue drops by 10%, if my revenue drops by 25%? Nobody had visualized the situation that my revenue would be zero and my expenditure level will be more or less the same. So how do you do the revenue recognition in situation when you are not sure whether you are a going concern? Then the other major issue which has come up for most of the Indian companies, I would say, is the debt covenants. All of them are heavily borrowed from public sector banks and other lenders. And there, all those financial covenants are there. EBITDA to net debt ratio, interest coverage ratio. Now, all these ratios, many of the corporates are not able to fulfill. And what is the trigger? Immediately it gets an ability to lender to recall the loan, which will virtually drive the company to bankruptcy. So I think a lot of these people are required to meet the lenders, key lenders, and convince them to allow the relaxation of some of the borrowing covenants which they have been doing, and also convince the auditors that we are still a going concern. We have not become bankrupt. The other major issue which many of the IT companies, many companies are facing, in fact, is the FX fluctuation. Foreign exchange fluctuation and its accounting impact, both losses and gains. And that's a very material impact under Ind AS. And that's really facing, bothering the kind of delaying the finalization of account. The other issue which auditors have raised with regard to the legal liability emerging from contractual obligations. Supply chains have been broken. The company has not fulfilled the supply contract. If the company was supplying some critical raw material for a particular factory and the company is not able to supply because of company's own production factory units are shut, then what is the liability of the company for breach of contract? Now, auditors are saying you provide for the full liability. Companies are saying we'll invoke the force majeure clause. Now, all those discussions are going on. Similarly, if there are companies have entered into any M&A transaction and if the company is the acquirer and the deal is between signing and closing, whether we should invoke a MAC clause, I don't want to take any further liability when I have already so many issues. Whether I need to make any insurance claim and how it will be treated by accounting. But the most important issue which is facing many corporates is that many auditors have raised the issue of going concern. And all of you know that if the company ceases to be a going concern, it means that company's net worth is negative. They're completely, the accounting implications change. Then the entire accounting treatment changes the moment the company is not a going concern. And how to report this in the financial statement has become a very big debating point between the company and the auditors. Now I come to the slide. The board also needs to look out for some of the market situations. If you are large public listed company with a significant public shareholding, there is a possibility that there is somebody who is making a hostile acquisition. I will deal with this issue. Day before yesterday, Government of India notified the changes in our consolidated FDI policy, prohibiting investments or even takeovers by companies which are located in the countries which are connected by land with the country. Obviously, it is targeted in China. And what would it? I'll separately deal with it. But is there because the valuations have become very poor and index has declined, The stock market declined by 30% in 18 days. It has never happened. So all the listed companies are currently available at a very attractive prices. And there are companies sitting with pile of cash and dry powder. So is the company a potential target for a hostile takeover? Are there any activist shareholders acquiring stake in the company? Keep a watch on that. Reach out to the government. The other issue which is bothering many of the corporate is the cyber security risk. For one font of time, I won't deal with it, but I think the boards need to ensure that the company has an effective IT security plan to ensure that there are no data breaches which happen, which have a potential liability for the company, and also potential legal exposure because of secret information of the company, the kind of company getting leaked out. And the other major issue which many boards are secretly debating, privately debating, not in the presence of the management team, is that the NRC is meeting more often on the phone to discuss a contingency plan for the top management team of the company. God forbid if any of the CEO or any of the key management team member contacts COVID, which is not unlikely, and unfortunately, if a disaster happens, then is the company ready with a contingency plan that who is the successor which can take over at a short notice, and the company does not suffer a business continuity risk because of a loss of a very vital member of the management team. So there are a host of issues which board needs to consider, but the golden rule is please augment the capacity of the management team. Don't become a burden on the management team. In fact, I was told that many boards have started insisting on the CEO that I give me a certificate signed by CEO, CFO, General Counsel, and Company Secretary that company has complied with in letter and spirit the lockdown orders. As Rashmi mentioned, violation of the lockdown order is punishable under Section 188 of IPC, Section 51 of the Disaster Management Act. So directors have a personal criminal liability arising under those statutes which provide for 6 months imprisonment. So no director wants to take a chance. So they are taking certificates from the management team that please confirm that you have completely complied with the lockdown orders in letter and spirit. So these are some of the very major issues faced by the management team in India. Also, there's the CSR angle which has come up that now CSR, any expenditure incurred and particularly contribution to Prime Minister's fund is regarded as a CSR activity for COVID-19. So many CSR committees are reworking on their annual allocation for 2020-21 to see that they can kind of contribute to the national development and contribute in this hour of crisis to the nation. And many of the corporates have already announced very large donations to Prime Minister's fund. Now I want to deal with some of the regulatory relaxations which MCA and SEBI have announced. I'm going to deal with major ones because of time constraint. As I told you, there are a host of regulations, relaxations which are announced by Income Tax Department, Director General of Foreign Trade. We are keeping a complete track of it. If you need any guidance, please do reach out to us. As far as MCA is concerned, MCA has so far announced two major relaxations. One is that they have allowed the boards to meet virtually. Obviously, even if 12-15 members of the board meet in one boardroom, the chances of infections getting passed on are very high. So at least till further, they've allowed that the boards can meet virtually. Secondly, as all of you would have seen last week, the MCA came out with two vital circulars, 8th April and 13th April, where they have effectively allowed conduct of EGMs, which will be held till 30th June 2020 for transacting urgent items of business by either you do it by audio visual means if it is EGM, or you can do a postal ballot for every item of the agenda. And you need not have a physical dispatch of notice of meeting. You can just send the meeting to those shareholders whose email address is registered with the company. This is a very extraordinary step they have taken without amending the act, without amending the rules, without giving any exemption, using any exemption notification. Some people have reached out to us for our opinion on whether this is valid legally. Can they raise capital basis, this kind of circulars? So all these issues have come up. Second very major relaxation, in my opinion, which is given to the accounting community and auditing community is the SCARO 2020. I don't think people had realized SCARO 2020 was notified in February. By the time an Institute of Chartered Accountants of India came out with some 400-page guidance note, it was so complicated and it would have further delayed the finalization of accounts for 31st March 2020. So government very wisely have extended the date to that it will apply from financial year, next financial year, not from the current financial year. And now I want to turn to say, and government has also come out with the clarification on what will be regarded as CSR and what would not be regarded as CSR. but these are all matters of detail which can separately dealt with. Similarly, SEBI has made significant relaxation in LODR in terms of the timelines for quarterly, yearly filings, timelines for the board meeting and audit various committee meetings. And importantly, day before yesterday, they also notified amendment to the takeover code, relaxation in the regulation 29 of the LODR by saying that whatever you are required to do with a 5 days notice to stock exchange, you can do it with 2 working days notice to stock exchange, which is very helpful for many companies because, you know, accounts finalization, you require 5 days notice to stock exchange, which may not be feasible in the current situation. Very important relaxations. Next slide, please. This is most important. You know, day before yesterday, Government of India made an amendment to the FDI policy with a press note 3, which basically says that you will require government approval for investments where the investor or the beneficial owner of investment is from a country in which India shares the border. You know why this technical language? Why not straight away say China? Because it would have, it would have created problem at WTO. We can't do country-specific restrictions. So now what they've done is that they've said that we are sharing land borders with whom? Pakistan, Bangladesh, China. Now, whether Hong Kong, which is a specially administered region of People's Republic of China from 1997 under a treaty signed with the British government, will it be regarded as also a part of China? And so the investments and LPs particularly which are based in Hong Kong, because the beneficial owner will be, if beneficial owner is located in China or Hong Kong, those investments would require government approval. Now, whether Hong Kong would be included or not is a matter of debate, and a lot of legal positions are being explored by law firms. The other issue which has come up, which is very interesting, is that how are you going to determine beneficial ownership? Are you going to use the SBO rules to determine beneficial ownership? Or would you use the rules under the FDI policy with regard to owned and controlled principle? Or are you going to use the, any other definition given under Prevention of Money Laundering Act? Or you're going to use the definition given under Income Tax Act? So these are all, or under Benami Act. So there's a whole host of issues, and still formal notification under FEMA has not been issued and is expected any moment now. Now,
if I can just add over here, Bharat, on this press note 3 point, I mean, this has a lot of practical implications for a lot of startup companies also which are expecting Chinese investments. So apart from the Hong Kong question and also what is the meaning of beneficial owner, I think there are also issues on how this will affect FPI. So the view that is being taken is that at least as far as FPI investment is concerned, this should not apply, but there's a lot of gray area surrounding this. So practically, this is one of the most important issues which is now currently engaging the attention of a lot of law firms and investment decisions. So this is, I think this is going to evolve very rapidly.
Yes, and also importantly is that a formal
and this will have a direct impact on deal activity, and also for companies which require quick liquidity, which may be coming from their existing foreign investors or from sort of new investment funds, which somewhere might have a Chinese angle.
Completely agree. And also, sir, there's a very important issue which is coming, which will happen is that my sense is that, the last line of the government circular says that this will come into effect when the formal FEMA notification is issued. And as all of you know, now for the capital account, now the power is with the Ministry of Finance and not with RBI. So the non-debt instrument rules 2019 will have to be amended. And my sense is many of these issues which Mr. Shroff raised may get clarified in the detailed notification which will come from the Ministry of Finance, Department of Economic Affairs in the due course. Now, there's one important thing which I want to point out. It's in the context of force majeure is that, as most of you may be aware, in much earlier, see, WHO declared this as a pandemic on March 11, but much earlier, somewhere in February 19th, Ministry of Finance has already declared this entire COVID-19 pandemic as a force majeure event for the purpose of government contracts. Next slide, please.
Just on this itself, there was also a news item that SEBI has sent notices to a lot of companies in Cayman Islands and Mauritius, asking for declaration about their Chinese presence of Chinese investment.
Okay, now I'll briefly touch base upon some of these things which have been announced by RBI, and I'm sure most of you are already aware of it, that some temporary relief or forbearance has been granted by RBI for term loans and cash credit and overdraft facilities. The 3 months moratorium for principal plus interest for anything which was falling due between March 1 and 31st May. So this is a very significant relaxation which has been granted by RBI with a lot of clarifications which have come later on, which I shall not deal with right now. And of course, cash credit and overdraft facility also, the interest accrued but not payable from March 1 to May 31st. In principle of repayment obligation continues. The other thing is that SBI has announced additional 10% of existing first fund-based working capital limit, subject to a total cap of 200 crores for every borrower. These 10% existing fund-based working capital limit which is sanctioned, they will go 10% more. Then, of course, IBC situation. So what has happened is that first thing Government of India did was that they knew that many of the MSME units may go into a bankruptcy situation. And currently, prior to the notification of government, the limit was that if you are, if there's a debt of 1 lakh and above, the creditor can file for IBC. Now they immediately increase the limit to 1 crore. So very measures primarily targeted benefiting the MSME sector from going into IBC. The second thing they done was that the entire period during lockdown is that kind of will not be counted in computing the time limit under IBC, which is very defined in the Act. And the third thing which they have done, which is not done but expected any time, because there's a lot of debate in the media, that if this situation does not improve, the Government of India may come out with a notification suspending invocation of IBC by anybody for a period of 6 months. But I must clarify, this has not happened yet, but likely to happen. That's what the media reports say. Now, the judiciary also has done a lot of innovations in this regard. For the first time I have seen in my career that we have a situation where all the 3 organs of the government were shut. The most of the departments of the government were shut. So executive was shut. Parliament had to adjourn sine die after passing finance bills. So parliament in state assemblies are shut, and judiciary is also impacted. So first thing which Supreme Court has done, and again, in my opinion, for the first time I've seen, an extraordinary power used under Article 141 and 142 of the Constitution, which only Supreme Court has, nobody else has, that all the limitations period prescribed under Limitation Act 1963 in all proceedings before courts and tribunals in India will be extended with effect from 15 March till further orders of the Supreme Court. So this order is binding on all courts and tribunals in India. Extraordinary order. The second thing is that Supreme Court has also, the necessity is a mother of all inventions or adaptations. Now, video technology was available, but nobody ever thought of it. But now Supreme Court was also, as we all know, taking up only very urgent matters but through video conferencing. So there is no physical requirement of counsel or anybody to appear in court. CCI, NCLT and NCLAT have closed down till May 3rd. And some courts have also issued that no adverse order be passed. Then injunctions have been also, most of the high courts have issued an order saying that if there are interim injunctions granted, they will continue till the next date of hearing. So extraordinary, never seen before. And as I told you that there are contractual disputes which are expected now, and our firm is getting a lot of inquiries from various lessors and various lessees with regard to whether they should be invoking a force majeure clause. There are many transactions ongoing where they should invoke material adverse change or MAE clause. What could I do? Can I not pay the landlord for a couple of months? Will he terminate my lease because of default in payment of my obligations? And Rashmi referred to various employment and labor disputes which have come up and which are coming up. So our COVID advisory team has been extremely busy. Let me tell you that we are working almost round the clock, all 7 days a week. Next slide, please. Now, this is the last slide which I want to deal with very briefly. As Mr. Shroff mentioned, we are doing it a very detailed presentation with Dr. Singhvi on 24th. So I will give you a kind of a 35,000 feet of view of this matter. Force majeure. What is force majeure? Force majeure is a French term which essentially means superior force. There is some event which parties had not foreseen when they signed the contract, but which has happened, and which completely goes to the root of the contract and which makes the performance of the contractual obligations by any party to the contract almost impossible. Then you can invoke the force majeure clause if you have one such clause in a contract. The interesting debate is whether COVID-19 is an act of God or it is not an act of God. Somebody says it is an act of China. I don't want to go into that debate, but I can tell you there are enough judgments of the American courts and some Indian Supreme Court judgments, which would later, it will be safe to conclude that COVID-19 is a pandemic, which is a natural calamity and should be regarded as an act of God. Because what has happened, unfortunately, most of the FM clauses which I've seen in contracts recently, nobody has written about pandemic or epidemic, because last pandemic happened, major pandemic happened was in 1918 Spanish flu, where almost 5% of India's population died, and none of the people who were there at the time are existing now. So the lawyers forgot about pandemic in writing in the force majeure clause, but I think now they will become wiser and write about it. Now, Indian law on force majeure is contained in two sections of the Indian Contract Act drafted by Sir Stephen. One is section 32, which deals with contingent contract, and one is section 56, which deals with impossibility of performance. What Indian law says that if your contract has a force majeure clause, you will be falling under 32. If it does not have a force majeure clause, you will go under impossibility of performance, which is called supervening impossibility, where event which has happened subsequently, which makes the performance of contract impossible. I must make it clear here, the Supreme Court has again and again held that impossibility should not be read as in literal sense, that it is physically impossible. Even if it goes to the very root of the contract or the basis on which parties had negotiated the bargain, this clause can be invoked. But one thing which Supreme Court has said in various decisions is that commercial hardship to a party is not impossibility. So if you find that the contract has become very expensive for me to perform, you can't take a recourse under section 56. There are three major decisions of the Supreme Court, which I shall not deal with, but we'll deal with on 24th, are the first judgment of Satyaprata Ghosh of 1954 of Justice Banerjee. Second judgment is of Nayati Jute Mills, and third one is Avon Energy Watchdog of Justice Nariman, which summarizes all previous judgment. But it's a very tough standard. The party invoking the force majeure is a very high burden of proof, and the Indian courts have so far shown a high degree of restraint in allowing the party to walk out of their contractual obligations. And the legal implications are the contract becomes void, and any party which has received the benefit under the contract has to immediately hand over the benefit back. Principle of restitution articulated under section 65 of the Contract Act would apply, and it has to return the benefit. Now let me turn to MAC, material adverse change. What is MAC? This is more refined concept compared to all other concepts. This material adverse change or material adverse effect effectively means that when typically this is found in acquisition agreements like share purchase agreement or a merger agreement, where one company A has decided to acquire company B, and an event happens thereafter after signing of the agreement, which was not foreseen by either of the parties, which has made such a fundamental change in the prospects of the target that it becomes very, very difficult for the acquirer to continue the transaction at the same price. And so this clause is generally found in most of the contracts. I think the people started putting this clause somewhere in late 90s and early 2000s. When this 9/11 happened, I think everybody started putting MAC clause properly. In fact, this entire clause originated in England and then US, and the entire jurisprudence is more found there. India, we don't even have any case law on this. Now here, there are four cardinal principles which American courts have laid down for determining whether a material adverse change has happened. First principle is that the criteria for determining material adverse changes are both qualitative and quantitative. What I mean by qualitative and quantitative, first is what is the fundamental effect on the decline in the profitability of the target in terms of its EBITDA or revenue. And qualitative is the durational impact. You just don't look at a blip on the radar screen that just 3 months my cash flow is gone, so I will invoke force majeure. Material adverse change. The courts will simply not grant it. If you look at the decision of the American Supreme Court and the Delaware Supreme Court, there are 3 decisions available very clearly. Last one is Econ decision, which says of 2018, which says very clearly it should not be a blip on the radar screen. When court is looking at a MAC, the courts should, even if the clause is very widely worded, the courts would look at the entire commercial context in which the transaction was negotiated, and has the material adverse change was so profound that it virtually destroys the ability of earning the revenue or profitability of the target for the next several years. Its court is emphasized, it should not be few months, it should be several years. If the acquirer finds that now this target is not going to be viable for me for the next several years, the court has allowed the party to walk out of the contract, but the burden of proof is very heavy. And I'm sure Indian judiciary, which has so far not dealt with this issue, would adopt the same issue as far as MAC event is concerned. So judicial approach to MAC is very, very, in fact, can I tell you very interestingly, the entire concept of break free in English law came primarily because of this MAC clause. Because people started walking away from the deal, then the seller said, then I want a break fee. If you are walking away from the deal, because otherwise you have to prove damages for breach of contract. As you know, under Indian law, section 73, it's very tough to claim damages for breach of contract, and it will take several years. Even commercial courts in India take 5 to 6 years to decide these issues. So best thing people found was let us include a break-free agreement, break-free provision in the thing. Then a lot of refinements have happened in this clause, which I can't deal with today. But all I'm trying to say is that the judicial approach to MAC has been, the standard has been very, very strict. The party which is invoking the MAC has to kind of produce sufficient evidence which convinces the tribunal or the court that the impact is profound. The impact will prolong for 2, 3, 4 years, and it has completely destroyed the viability on which it will happen. In India, what has happened is that most of the people have used MAC clause to renegotiate the deal. Mr. Shroff has most experience on this. People have come on the table, I don't want to go to the court. Let me sit with the seller and sit with him, and I will buy it at this price, whether you would take it or leave it. And that's how people have mostly avoided going to the courts or arbitration tribunals and resolve the issues out of the court. So this is what very broadly, these are very involved topics, and Mr. Shroff is going to take it with me, Dr. Singh, with great detail on 24th. If you want to know more about it, I would strongly recommend to all of you to attend that program on 24th. So thank you very much for your patient listening, and now we'll be happy to take few questions.
Okay, so this is one of the questions from Sunita Kirplani. Says, hello Cyril, so this is for you. Thank you for your insights. I work for an art and design company wherein we design and produce artworks to enhance a space to convey the corporate message and help corporates tell a story. In this new emerging market, since the world is no longer the same, how do non-essential industries such as mine survive the global impact of this pandemic? Since most of our clients will also be impacted to some extent, what is it that we need to do to stay in the green? How do we ensure employability and profitability in 2020?
That's a great question. And I think the short answer is try to go digital in terms of both your outreach as well as in terms of innovation. Of course, the physical world, I think, will definitely continue to be relevant. So try and find a right mix between the physical and the digital world. But the digital world is going to become more important because definitely I think life has changed. In terms of and social distancing, I think is going to be around for quite some time. Even if the lockdown is lifted, I see the social distancing phenomenon there for a couple of years at least, till a complete cure and a vaccine is found. And even then thereafter, I think habits would have changed. So I think we all have to recognize the reality that the world is very different now, and therefore bring your creativity and apply it to a more digital world. And there are a lot of options in how you can do that as well. I'm not saying give up creativity in the physical world, but change the emphasis.
The next question I will take, which is on this on the MHA order and whether it's valid under the Constitution of India and whether it is binding on employers and contractors. So like I mentioned, the MHA order of 29th March was to deal with migrant workers. However, and in relation to migrant workers and the part of how they should be treated when migrating back to their home states, it's definitely valid. The only question is whether on the point of where they direct employers to make payments to their workers and go beyond the scope of just dealing with a migrant worker situation in the lockdown and arising out of state lockdown of borders. That is something that can be questioned, and which is what is actually happening in the Nagrika export case. So it will be interesting to see how that pans out. But right now, the MHA order has been interpreted, including by the Chief Labour Commissioner, to have wider import, not restricted only to migrant workers. And it also, if you look at the CLC order, it specifically refers to obligations on the principal employer, so therefore covering also your contract work.
So, Rashmi, can I just add one more point? So you need to know that the MHA order of 29th March is passed under Section 10(2)(I) of the Disaster Management Act. And there's a debate going on in the legal circle that whether the Home Secretary, which is the designated authority under Disaster Management Act, has the whether the order passed is ultra vires section 10(2)(i). 10(2)(i) deals with something and you are passing order something else. So that issue will eventually get settled when this petition is heard in the Supreme Court. So the constitutional validity under 10(2)(i) itself is a bit of a question mark. But you need to know that section 72 of the Disaster Management Act says that this act overrides all other laws. And section 64 of the Disaster Management Act says that the authority has a power to modify all other rules, regulations, bylaws. So all the delegated legislation can be modified by the Disaster Management Authority by invoking power under section 64 of the Disaster Management.
So, okay, there's a question from Vipin Parashar. If any employee or contractual employee does not come to attend work of essential services by saying he is on quarantine and cannot come due to lack of transport or other reason, then do the employers to pay require to pay wages to such employee, or will it put their employee at par with those who are coming on duty? What should employers do? Yeah, so if there is a genuine reason why employees are unable to come to work, which is that he is in maybe a hotspot or a containment zone, etc., but is otherwise willing to come to work, then yes, employers should pay wages during that period of time. However, if an employee is, despite having facilities to come to work, that is, if the employer arranges for transport, etc., and is still refusing to come to work in an essential services, then action can be taken against him. But of course, make sure that your action is tempered given the circumstances. Maybe put him on leave without pay, but not essentially terminate him. But you will have to look at this on a case-by-case analysis and then take the right decision for that employee and for you. So one of the questions from Saurabh Sharma is there any specific exemption provided to startups registered with the DP IIT on advisory orders? Mr. Vasani, anything that you are aware of?
I am not seeing any specific such exemption given to startup orders, but I must add a rider. As you would have seen from Rashmi's presentation, both Rashmi and I are tracking all these notifications and advisories by an hour. It's almost, there is not a single day passed when such notifications and advisories have not been amended since early March, second week of March. And virtually there are 5 orders passed by various authorities in every state. So to the best of our knowledge, no such order has been passed for the start.
Another question for me, while you have provided for layoff provisions for factories, in your view, is it applicable to commercial establishments also? Can a private commercial establishment lay off? So the layoff provisions under the Industrial Disputes Act are only applicable to factories, mines and plantations and not to commercial establishments. So the only way that you can reduce salary in a commercial establishment is by taking consent of employees. So due to relaxation of Regulation 29, Mr. Vasani, this is for you. Now, intimation of board meetings for consideration of board meetings for financial results require 2 days or 4 days time?
2 working days. 2 working days. Please keep important. If there are intervening holidays, then obviously it will go up.
Another question, I think you kind of covered this, but does Press Note 3 also cover Hong Kong and Macau, given they are SARs?
Well, it's an issue which is currently under examination. My sense is that the formal notification which will come out under FEMA will clarify this aspect. From 97, Hong Kong is a specially administered region of People's Republic of China. So it's somewhat analogous to what was JNK for us prior to this amendment of the articles of the Constitution. So it is just a special administered region, but it's a part of the territory of China. And so the government will have to clarify this aspect. I suspect that some clarification will emerge after the formal FEMA notification is issued.
A couple of questions on IBC. As for the revised notification, the threshold for IBC for filing is INR 1 crore. Will this remain for a long tenure, or can we expect it to be rolled back to 1 lakh when things are normal or after 6 months?
I'm not an astrologer, so I can't predict which way it will go. But my sense is that we are in crisis for a long haul. We are not here for 1 month or 2 months. This virus is not going to disappear from this planet in a very easily till the vaccine or medication is invented. I don't think, given the grief in which currently the Indian industry is, that Government of India would be quick to roll back. But as I told you, these are matters of executive decisions, and where the government will have to take a call at an appropriate time.
Another question on CSR, Mr. Vasani. Since expenditure on COVID is now under CSR and money under categories like district mineral fund, etc., is being used for COVID, is it possible for companies to ask for a set-off?
Well, as of today, the Income Tax Act is not amended. So, I suppose you are basically claiming that whether this amount can be used as a deduction while computing your taxable income under the Income Tax Act. As of today, no formal notification has been issued to allow CSR expenditure to be part of a deductible expenditure under the Income Tax Act.
A question on courts, Mr. Vasani. Do you expect courts to suspend summer vacations? How is pendency likely to be dealt with? Any other innovation likely?
My request would be to direct this question to the Chief Justice of India. The requests are made and some of the courts are looking at that issue, but I suspect the Chief Justice of the High Courts and Chief Justice of India will decide about Supreme Court and High Courts. Very difficult for me as a practitioner to comment on this.
So let me add on this. I think 2-3 things. Firstly, I think there is going to be a tremendous amount of judicial innovation because I think the era of a crowded courtroom is over. At the moment, of course, the courts are using technology and video conferencing to hear urgent matters, but a more permanent change, I think, is likely to come. All the courts and right down from the Supreme Court are looking at this issue. So I think expect a whole new dispute resolution system in the years to come. And there is a tremendous momentum both from the judiciary as well as from the bar. So that's point number one. As far as summer vacations are concerned, I think some courts are already trying to sort of cancel them because the arrears are just blocking up and are piling up. At the moment only urgent matters are being taken. So I think that there is a sort of a judicial view that access to justice should not be denied. So I do expect that most courts will cancel their summer vacation.
I'm taking the next question that I will address. Sorry, I've lost it. Yeah. Can we deduct or consider the days of lockdown as paid leaves and deducted from employees' leaves? So strictly speaking, not without the consent of the employee. In most cases, we have seen that this consent is quite forthcoming. So as long as you're transparent in your communication with them, I think most employees will give you consent to deduct from paid leave. But this is something that you will have to get consent. In states like Telangana, they have actually declared paid holidays for the period of the lockdown. In case of companies which has complete reliance on the government projects like construction, suggest how these companies should manage their working capital. Mr. Vasani, any thoughts here?
Well, conserving cash is I tell you the basic rule world over for in this kind of crisis. Now, how this would they manage the cash flow and working capital? I think they should plead with the government to release the payments early because that is the only way government is contemplating various stimuluses. So I think you should approach the right ministry in the government to say that we otherwise will go completely dry on cash flow unless some of our payments are released. But there cannot be a legal answer to this. It's a more a practical issue. How do you manage your working capital? All I can say is that there are people who negotiate with the supplier that please will defer the payment by 3 months, don't charge interest. There are people who have negotiated with the landlord that will not pay the rent for 3 months, please bear with us. So there are different ways and means practically for each business and which sector you are operating, but you can't give a standard answer for everybody. But working capital management has become the heart of the current problem because of the way the situation emerged. Because nobody expected that the cash flow can dry up to almost negative in a matter of few weeks.
Mr. Vasani, next question also for you. Have there been any thoughts doing rounds in the MCA or the SEBI on AGMs to be conducted by 30th June?
AGMs to be conducted by 30th June? Well, no. I must clarify that Circular 8 and Circular 13 both, 8th April and 13th April Circular only deal with AGMs. My sense is that if they have to do it for AGM, it will require amendment of the Companies Act by an ordinance. And I suspect the right decisions will be taken at the right time by the authorities, because AGM season typically in most companies in July, August, September, mostly August, September period, and they will take a call near closer to the time because not allowing AGM, it will require amendment of the Companies Act because the ordinary items of business cannot be done by a postal ballot under 110, which all of you know. So they will have to kind of work out a mechanism by an ordinance or a specific exemption notification under section 462(2) of the Companies Act. One of the two they have to do. Without that, they won't be able to make relaxations for AGM, but I think it will be considered at the right time. I don't think the AGM season has yet arrived. It will come in from July, August, September, around that time. If the infections continue at such rate.
Mr. Shroff, a question for you, whether additional foreign investment from China in existing Chinese subsidiaries will also require government approval. What about setting up step-down subsidiaries by those companies?
I think this requires a clarification. The press note is very broadly worded, so let's see what clarification comes and what the FEMA notification says.
Mr. Shroff, most probably it will come in FEMA notification.
Yeah, but it's a real issue, and I hope the government takes a practical view.
Yeah, so a question that I'm going to take, we see that a lot of startups are facing employee issues, including employees not adhering to work from home norms. In such instances, if the employees are not working from home, that is not working the requisite hours, can startups amend their terms of service if the employment agreement provides for the same? Further, can this be a legitimate ground for termination of such employees? So yeah, you are under the current regulations required, you are able to require employees to work from home. So if you have employees refusing to work from home, I think you are well within your rights to take disciplinary action against them, whether follow the process which is under your employment policies on people who abscond from work, people who refuse to, insubordination, refuse to, give the requisite output, etc. So you should be able to do that. I don't think this should come within the banquet plan not to terminate employees. Just make sure that you follow the processes that your policies have very clearly set out. Okay, so the next question on rent, Mr. Vasani, if the building where the rental premises is under lockdown, are we still entitled to pay rent?
See, the current provisions of the law, whether the contract will be governed by the Contract Act Section 56 or the Transfer of Property Act itself is under debate. Your obligation to pay rent continues till the court declares it as a force majeure and kind of gives you a complete exit from the contract. Until such time, nobody can rewrite the contract. Even court cannot rewrite the contract. So essentially, your obligation to pay continues unless your landlord is kind and willing. And many landlords, I must tell you, have agreed to grant a waiver for few months. Many landlords I have heard, I'm advising many clients, and the landlords have been very sympathetic to the current situation, and they, if not complete waiver, a partial waiver has been agreed, deferment has been agreed. So there are multiple options. You can't look at it in a binary way. There are multiple options which are emerging in the market. People are going to from rent to the revenue share model for large retail formats. They find that they don't know when the footfalls will again come on the retail space. When would the customers would develop confidence of going in a large departmental stores to buy to do the shopping? So they are worried that this situation may continue for 9-12 months till the customers come back. So many of the chain are even renegotiating the entire lease terms and saying that let's go on a revenue share. If I earn, I'll share it with you.
I think there are three categories, Rashmi. One is residential, the second is commercial, and the third is things like malls and shopping malls and others. So for residential and for malls, I think what Bharat said is right. We are finding a greater degree of inflexibility on commercial office space, where the landlords are taking a slightly harder stance. Now, whether it's right or wrong is a different matter. It's just a reality.
So question on CSR. In Maharashtra, the CM Relief Fund is not under CSR. Then which fund declared by Government of Maharashtra should we consider for CSR? So Vasani, any idea?
I would not like to specifically answer this question because it has political connotations. I wouldn't like to answer this question.
Okay. Is there any announcement, Mr. Vasani, for extension of financial year from 12 months to 15 months?
The government, as per the last discussion, has categorically ruled out that they intend to change the financial year from 12 months to 15 months. And some of the companies you must have seen, like TCS, have already declared the results for 31st March. Most of the IT companies have come out with the results. There is no plan, to the best of our knowledge, of government planning to extend the financial year. The principal argument is that up till 15th March, everything was by and large normal. For 15 days, why do you want to contaminate? Because the next quarter is going to be even worse than this. So why do you want to contaminate the results for the entire year? The virus was there in the later part of March, in India particularly more pronounced. Up to 15th March, most of the people worked quite normally. So that is the argument was most of the thinking of the government is. But as of today, nothing is announced. And I don't see any plan also.
So one question that I'm going to take is, should we consider directives issued by the central government and state government directory or mandatory, and will a violation attract penal provisions? So after the Supreme Court order in the migrant labor case, I think it's clear that the expectation is to treat them as mandatory right now, and any violation will attract penal provisions. This is of course subject to any challenge on constitutionality of these directives itself. Should we take a few FM questions, Mr. Shroff?
Sure. Only if they're high level, because it's sort of going into the space of the Friday session.
Sure. I believe everyone is going to invoke FM in a contract. If both parties trigger FM, then how does FM clause, how can it be dealt with?
If both parties trigger FM, it's simple. It's you negotiate a new contract, no question. Yeah. Both of you sit across the table that this contract is not performable, and you sit across the table.
I think the challenges are when one side is invoking FM and the other is denying it.
Yes, that's the challenge. Not when both the parties are on the same side. You know?
Correct.
So, Mr. Vasani, this is for you. Can the company incur CSR spend by adopting COVID-19 expenditure for employees and their families?
Well, the cardinal principle of CSR is that substantially it should be for the outsiders. What you spend for your families would technically not amount to CSR as per the earlier act and the rules which have not been amended. So I don't know, this is the call which Mr. Ministry of Corporate Affairs will have to take, but I don't believe that expenditure which you incur for your employees will also qualify as a CSR expenditure. It's corporate social responsibility, not corporate employees' responsibility.
Okay. Another question that I'll take. There has been news of the Karnataka CM telling ITBT companies not to lay off and instead cut salaries. How should this be read? What is the position for other states? Are any industry bodies following up with the government of Maharashtra for similar solutions? So yeah, we've seen the news report, but it hasn't been followed by any any formal notification. I think it's interesting to see that many of the states have actually cut salaries or deferred salaries of their government employees. But right now there is no clarity on them deviating from the directions that have been issued by the center, both at the Labour Department and also the MHA. So Vasani, another question for you. What about the timelines of RBI filings, that is FCTRS and FCGPR? Have they provided any relaxations in filing dates and late filing fees?
RBI has allowed a lot of relaxations now, specifically for FCGPR and FCTRS. I need to check out and come back to you. Can I come back to you, because there are so many notifications that I need to check whether these two particular forms are covered or not. I need to check that.
Mr. Shroff, a question for you. Whether investments from China coming from the companies whose ultimate ownership is not Chinese or Chinese national will also be impacted? Say the ultimate ownership is European.
I think the notification or the press note actually is a bit ambiguous just now. So I would not want to take a categorical view, because we are seeing the authorities take a very technical view of this. So I would play cautious and wait for the clarification.
So a question that I'll take for workspace guidelines, can you clarify if parents of children with who are less than 5 years old are expected to work from home? Is it recommendatory or mandatory? We are in the process of filing application to Haryana government to start operations, and any inputs would be helpful. So currently it says that they should be encouraged to work from home. So it's not mandatory in that nature, but to the extent possible, you should try and comply with that requirement of allowing them to work from home. Assuming that there is the ability to work from home, that particular role. Mr. Vasani, another one for you. By virtue of the revision on the FDI policy on Saturday, April 18th, where government has restricted investment, especially by Chinese companies, from investing in vulnerable Indian companies, can that have an impact on companies operating in India under Chinese flagship companies and other contracts such as procurement of goods from Chinese manufacturers in various sectors?
I think as of today, what we have is only a press note issued, which is very brief, and as Mr. Shroff clarified, it's still little vague. It certainly does not deal with commercial contracts and purchase and sell contracts. It only deals with acquiring investment by Chinese companies or countries in the neighboring region in FDI instruments and takeover of such companies. So I would urge you to wait for the formal notification under FEMA, under non-debt instrument rules when they come out. Many of these aspects on interpretation of beneficial ownership and interpretation of what is China, whether it includes Hong Kong and Macau, everything will be sorted out there. Just now, I think with the divorce of the notification, it is difficult to advise.
Rashmi, I've got a question on my WhatsApp. Can MHA order dated 29 March be treated as a change in law?
For what purposes, but depends on what you're relying on it for.
Yeah, I mean, probably for the purpose under a contract, under an infrastructure contract.
So whether it would fall, I think that's an interesting question. For obligations that would arise out of that because of the fact that you have to continue to make payments, whether you can, not sure
Rashmi,
about Vasani.
Yeah, my view would be
I think it would.
It would,
Yeah.
My view is the same, that basically you are operating under a particular set of law and circumstances because of which you made certain contractual commitment. Now, if a new law comes, which is an overriding law because of Section 72, and which virtually suspends all your movement, it is a change of law. I would like to believe that the courts in India would treat Invocation of Disaster Management Act and Epidemic Diseases Act as a change of law.
But I think a lot will depend upon the actual wording of the contract, because many concession agreements and infrastructure contracts do have change in law provisions. And I think what we'll have to see over there is whether change in law language is broad enough to cover sort of regulatory notifications like this. Because it's not a change in legislation, but it's a change in the legal situation because of the invocation of the act.
Yeah.
But basically, I think the answer would be yes, it is a change in law.
Another question which I'll take is notice of termination for annual performance reasons not linked to COVID. Can someone be terminated? Yeah, as long as these are genuine reasons and you're following the process that you would ordinarily have followed, you should be able to do it. But it's important that you're not, you're not kind of couching this as a performance reason and getting rid of 400, 500 employees. As long as it's genuine, in most cases, these, performance improvement plans, etc., people would have already been put on it prior to the lockdown period. As long as it's a conclusion of that process, it should be fine. Mr. Vasani, one for you. Under the Companies Act, a CEO appointment has to be done through a board meeting. Under the present circumstances, can the appointment be carried out through resolution?
But you can meet virtually. Why do you need? You can just meet over a video conference or a Zoom call and do it. Virtual board meetings are allowed, so where is the need for physical board meeting? But an item which is required to be done at a board meeting, you can't just say that I will do through a circular resolution. Then let the board discuss. And again, first of all, the NRC has to recommend that appointment. The board cannot straight away appoint a CEO. The NRC has to recommend the appointment of a CEO. NRC can also meet virtually, and thereafter the board can meet virtually, and they can decide and appoint the CEO.
Mr. Shroff, a question for you. Will the recent changes in the FDI norms, border countries, have any adverse impact on in the VC and PE space, especially the LP is a Chinese person?
Absolutely. I made that comment when I sort of intervened at the time of the slides. I think they're going to be badly hit because a lot of them have Chinese venture capital or private equity investment. That's going to be a very hard hit sector. But hopefully there will be more nuance to it, and there should be some clarification on Hong Kong and also in terms of materiality. Let's see. But at the moment, I think it is quite severe.
Another interesting question. Since the center and state government have exempted the operations of e-pharmacies and have categorized them as essential services, will the center finally issue notifications to regulate and recognize their existence? A good question.
Yeah, great question. I think the practical treatment will treat them as a sector. I don't expect any formal notification. I don't expect them to change the law. But it's a very good, interesting thought.
So one of the questions for me is all the advisories on layoff and terminations are only applicable during the lockdown. Will this continue thereafter? Currently, it is only during the lockdown period. The expectation is that all of this will fall away once the lockdown is over. But to the extent of social distancing and other norms that have to be followed, the expectation is that those will continue until we have greater clarity on how we are going to contain the spread of COVID-19. So Vasani, for you, will COVID-19 testing conducted by diagnostic centers, pharma research companies also qualify as CSR?
the testing laboratories are charging money. CSR is when you are doing contribution for certain expenditure. Since you are charging money now, if the CSR, this COVID-19 test is costing them 9,000 rupees, and they are charging 4,500 rupees, perhaps 4,500 they can claim as a CSR rebate. But I don't think if they are recovering their cost, I do not know the economics of how they operate. But if their economics, currently, as I understand, all these private laboratories are charging for the test they are conducting, and I think the test charges fixed by the government are 4,500 bucks for normal test. But it requires examination. It requires examination of how much is their actual cost.
So another question that I'll take is, being an essential service provider, whether an employer can deduct the salary due to absence of service from employee. So if you go by the Goa Labour Commissioner's directive, that if you're in an essential service and your employees refuse to turn up, then you will be within your rights to take action against them. And in certain states, like for example in Madhya Pradesh, I think the ESMA has been invoked. So if employees refuse to come to work, then you can take action against those employees. Another general question: what would the impact be on the IT and ITS sector?
The main challenge which they are finding it difficult to enforce currently is the social distancing norms. Second problem which has happened is that most of the IT companies, 55 to 60% of their revenue comes from the US. And you all know that US is very profoundly impacted by the COVID crisis. So there would be an impact. The only beneficial impact they have is the foreign exchange. See, all these contracts, all the service contracts which IT companies enter into are expressed in US dollars. And the dollar has significantly appreciated vis-a-vis Indian rupees. So there's a negative impact and there's a positive impact. How would actually it will play out? I will wait for the second quarter result.
Also, I think that, and I think TCS probably announced it in its annual report as well, that they expect that going forward in the future, only a small number of people will be working in offices. They forecast that only 25% of their workforce will be in an office.
Yes.
So it's very profound to say that 75% of their workforce will not be in an office. Now, this is just a forecast.
Another question that I'll take, can the government order of 29th March be interpreted to mean that companies cannot lay off or retrench their employees during this period by following provisions of the ID Act? Currently it appears that these directives and advisories would take precedence over the Industrial Disputes Act. So we will have to watch and see whether there's a successful challenge of these provisions. But right now, when dealing with workmen and employees, you should be very careful and be aware that state action could be launched against you in the event you take any adverse decisions.
Rashmi, the Supreme Court order, we can just add that, because it's a Supreme Court is an extraordinary power conferred by the Constitution in Article 142.
That's right.
Which is binding on every order passed by Supreme Court is binding on all courts and tribunals in India. So that courts and tribunals are likely to take a view which is pronounced by Supreme Court on 29th March, unless Supreme Court changes its own order. So shall we conclude, Mr. Shroff, now?
Yes, I think we should do that. I think we've had a very comprehensive conversation. I hope the participants have enjoyed this. If you have any questions, please write to us at the COVID ID. So thank you.
Thank you.